Good afternoon. Today is Thursday, the 30th of March 2017. My name is Karen Harding and I'm a criminal defence lawyer from Auckland, New Zealand. I'm also currently counsel acting for 30 Indonesian foreign fishermen who were victims in New Zealand of forced labour, which is human trafficking type practices, where they worked for a Korean fishing company on Korean foreign vessels here in New Zealand while on work permits fishing New Zealand quota fish. They say that they were not paid their minimum wage entitlements under the New Zealand Minimum Wages Act. They also didn't receive any holiday pay or any holidays. They worked 7 days a week, had to be on call 24 hours a day on 2-year contracts, and they worked on average 18 to 20 hours a day each. And they received $200 a month pay, up to $270 a month depending on what contract they're on, and that was for working 20 hours a day. And sometimes they worked longer than that, sometimes more than 24 hours in a row. So they ended up being exhausted and felt very upset about how they were treated and have a number of personal grievances. We filed litigation in the Employment Relations Authority seeking for these fishermen to be able to pursue personal grievances and to be able to recover minimum wages under the New Zealand Minimum Wages Act and the New Zealand Holiday Act. So what's happened is that the proceedings were moving towards having a hearing on preliminary legal issues about what they were entitled to, whether they were entitled to holiday pay, whether fishermen could make personal grievances. The Korean fishing company, through their lawyers, was saying that actually foreign fishermen who are here in New Zealand working legally on work permits cannot use the Employment Relations Authority or the Employment Court to pursue their employment relation problems by way of personal grievances. So it would be one whole class of a profession that cannot utilise a judicial service to resolve an employment dispute. I disagree with that, and I filed employment grievances in relation to that with the Employment Relations Authority. This case is rather old. The offending in relation to the treatment that they suffered occurred starting back in December 2007 with that particular fisherman coming off the vessel in December 2009. So I have 2 people from vessel Oyang 70 who have made a complaint to the Employment Relations Authority, and then I have another 5 who have made a complaint to the Employment Relations Authority from Oyang 77 vessel. Oyang 70 was a vessel that sank, and Oyang 77 was confiscated for fishing crimes, and the dates in relation to the time that they were on board go all the way up to 2010. But they had difficulties getting counsel. They were impoverished. They live in a third world country of Indonesia. They have no resources. It was very hard to get a lawyer. There's not many Karen Hardings out there who would agree to take them on, given their very sad financial situation and the very difficulties of accessing justice and the extreme amount of paperwork and other things that have got to be done in relation to their court case. We filed proceedings starting for the Oyang 70 clients back in December 2015. A year went by filing various documents in the ERA in Christchurch, and then there was due to be a hearing on February 2017, and the fishing company applied to transfer the proceedings to the Employment Court, ostensibly on a claim to remove a layer of appeals, and the matter was transferred to the Employment Court. I've since then been required to refile documents that we had in the ERA for the Employment Court, and one of our applications is that we wish to transfer the proceedings from the Employment Court in Christchurch to the Employment Court in Auckland. The main reason for that is I'm here based in Auckland, counsel for the defendant are based in Nelson, and we all have to travel to the Employment Court in Christchurch, and that's very expensive. And we would have significant cost savings for the litigation if we could do it in Auckland. I'm based in Albert Street, Auckland City, and the Employment Court is based in Wyndham Street. That's less than a 5-minute walk from my office. We're able to arrange accommodation for the plaintiffs nearby to the courthouse in my office and get them food, facilitate everything they need without a whole lot of expense. If we could do it in Auckland, subject to, of course, having to pay for the airfares for them to come out. There are also expert witnesses that would need to come that are based from Auckland. Whereas if we had to go to Christchurch, we would have to fly the plaintiffs from Indonesia to Christchurch, probably via Auckland down to Christchurch. We'd have lots of accommodation and hotel costs. I'd have to stay in hotels and have internal travel. We have excess baggage, we have a lot of paperwork. I had 61 kgs of paperwork at one point when I went down for a different hearing to do with the forfeiture applications relating to the fishing vessels, and altogether it would just facilitate a lot of savings if we could have it in Auckland. So I have made an application. I'm just going to go through the notice with you. This is a general information that informs my clients and their interested parties and family. We also need community support to help us with this litigation. It's a matter in the public interest. We need extensions, the biggest in New Zealand history, under Section 219 of the Employment Relations Act, to allow these claims to proceed, to allow the claims to proceed out of time. They are beyond the 6-year limit for making the claim under the Minimum Wages Act, and they are also beyond the 3-year rule for filing a personal grievance. However, I have found case law that can argue for these extensions, and we would like it to be argued in Auckland. If we can't argue the pre-trials in Auckland, I'd at least like to do them something a bit more handy like in Wellington. Otherwise I can of course go to Christchurch. It just costs the clients thousands of dollars each time I go, and it's money that they can't pay. And the other side, the fishing company says, oh well, if they win their application we can recover the cost from them. Well, maybe if they pay. They're a foreign company, they don't have any assets in New Zealand, their fishing vessels have been forfeited. They're a $1 billion company, or at least multi-millions, I think $1 billion company in South Korea. They're just not interested, as far as I can tell, in paying my clients their wages. And I am sure, beyond reasonable doubt, from the evidence I have collected, that they have not been paid their minimum wages. I have seen bank records from my clients' bank statements that they have not been paid. So this litigation has been going on for 2 years in relation to some parts of their claims, which have started in the Christchurch District Court about forfeiture of the fishing vessels and seeking those vessels to be sold to pay the wages. And that case is ongoing, and we are still waiting for a Court of Appeal decision about whether we can claim over vessel Oyang 75 to sell that to go towards paying wages. We're also seeking to sell a forfeited vessel Oyang 77 to pay wages. It's long-haul litigation, as it turns out. There's 11 subsections in Section 256 of the Fisheries Act, and it's taken 2 years to argue subsection 1. We're still waiting for a Court of Appeal decision, likely then to go to the Supreme Court. It's likely that the proceedings will transfer out of the District Court at Christchurch, because we're dealing with millions of dollars worth of wages outstanding for 13 fishermen and vessels worth collectively $8 million or more, so it's all likely to be transferred to have their trials in the High Court, which at this point is at Christchurch. What I want to do is avoid the costs of multi-jurisdictional litigations in different parts of New Zealand, and I want to be able to manage the proceedings. I have small office here in Auckland. I'm the sole lawyer here, but I have a good little office support team of legal assistants, and my secretary, and my personal assistant, and my practice manager. I've got my family here, but I also have Indonesian legal assistants who are able to provide interpreting services, translations, and just sort of moral support for the defendants who can't speak English and would need to be looked after and supervised, and we can manage the costs here better, and it would be fairer. And there is no company office in New Zealand anywhere. The fishing company is saying, oh well, we have a few people in Christchurch who were employed by the New Zealand charter partner, which was Southern Storm Fishing 2007 Limited, which is a struck-off company. They haven't identified the names of those people. They haven't provided us with any evidence about what those people will say. I've provided affidavits and evidence. They've provided nothing. Also, they'll have witnesses perhaps from Korea. They haven't identified who those people are, and their whole approach is really to try to squash the litigation by way of challenges to technical parts of the law, by saying out of time, breaching time limits, or where we are in time, or we are within what looks like the wording of the law. They try to argue different parts of the law and the words and what that might mean. And I'm getting considerable fight just on really basic little things like a transfer to Auckland. So what they would like to do is see this litigation run out of money and get sort of starved to death and sort of strangle from the costs of it. And so they're quite motivated, I think, to keep it in Christchurch. I don't see how that really changes their costs too much, they can afford to move their experts around. And if they're only talking about 4 people in Christchurch, that's small potatoes for us. And hell, I don't mind going down there for one day to do their 4 people, but I don't want to cut 30 fishermen around Christchurch. If I have to bring them here, then I want to manage them. And so we're doing a test case at the moment for 7 people, and we do need community support for it, because it's wrong to have slaves at sea. It's wrong for people not to be paid the minimum wages. It's wrong for people to be worked 7 days a week, 18, 20 hours a day, on call 24 hours a day, and it's wrong that they don't get paid for it. They exhausted these people, and they worked so hard, and they deserve to be paid. And their personal grievances are really quite serious as well. I mean, they relate to the way their employment contract was. It didn't comply with New Zealand law in any way whatsoever. And there were security conditions that they had to put up their house, their parents' house, vehicles, other property to guarantee their employment. So if they left their employment, their family will become homeless, because the agents for the defendant company, which is the Sajo Oyang Corporation in South Korea, would forfeit their house and take their property. So those things are really quite concerning to me, and that's what creates forced labour, the fact that there's a financial penalty to keep working for someone when you're being treated badly. They were treated badly. There was verbal abuse, there was sexual harassment, there was verbal harassment and beatings. There was some sexual offending that also occurred on those vessels, so the whole environment was quite toxic, it was oppressive, and they worked in fear. We've also got personal grievances in relation to some of the fishermen about personal injuries that occurred. They can't claim for the personal injury per se, because it should be covered by ACC, and while in respect of one of the fishermen, they took him to hospital to have his part of his hand amputated. They didn't tell him what the forms were he was signing for that, so he had an operation. The operation really wasn't with his consent, because he didn't know he was having an amputation. They didn't get him a translator, they didn't tell him what was happening, and then abandoned him for a while in a motel unit and bought him noodles, but they didn't explain to him what was going on. They didn't have someone interpreting. He was scared. Then they made him work with a hand that was infected. Extreme hours when he wasn't well, wasn't really able to handle the fish anyway, and in fear that he wasn't going to get his wages, because they were also withholding wages as security. So the promise was that, you work really hard for us, this 20 hours a day, 7 days a week for 2 years, never mind that you've lost part of your hand in a workplace injury that we've caused you, you keep working and we'll pay you at the end. Did not get paid at the end. So, and they suffered, and that particular person doesn't have a career anymore in fishing. That was his profession, because of the injury sustained by the defendant company, the Sajo Oyang Fishing Corporation, because of substandard equipment, like his gloves were ripped. So, when the workplace accident happened, which wasn't his fault, he was trying to save the life of a Korean officer, and his finger got chopped off. That's just really serious. Also, although they were forced labour at sea, we have personal grievances because 2 of the fishermen complained, and to make an example of them, they were humiliated in front of everyone and sent home and punished financially with all their with wages being withheld from them, so that they worked for what is fair to say is a pittance. If they were going under their contract for $200 a month, they didn't even get that really for 6 months, and they just suffered, and there were some beatings and other things that went on. It was just really gross, and it was a sustained breach of their rights that is it's really an unfair dismissal. So while they wanted to go home, they didn't want to go home like that, and they didn't want to not get paid their wages. And in my view, they should be paid holiday pay, no matter whatever the contract says. The contract didn't say anything about whether they should have holiday pay or not, but you don't treat people this badly, and they don't even get a day off to recover. Then you've got to pay them and recompense them, because this isn't on. And on top of that, the food situation was really disgusting. There was insects in the food, the bedding had cockroaches in it was wet, cold, one toilet between all the fishermen to use, no fresh water for bathing, and they had to bathe in salt water, which is sea water, in a big bath together, because they didn't even have individual showers. So it was just like this gigantic bathtub, and they all had to get in. So they got skin conditions. One of the fishermen, had to have a lot of his teeth taken out. His teeth were perfectly good before he went. Then he had medical tested, his teeth were very good. And his teeth rotted and fell out. It was disgusting. They couldn't even wash them properly. Couldn't even wash them in seawater. Couldn't wash their clothes. Had to drag them behind a net behind the boat. I mean, the facilities were disgusting. We call them abject. They were treated badly. And it's not good enough. So that's the case that I'm doing. And I have got a mountain of paperwork that I have to file now. So the first of that was dealing with a strikeout application. So I had to file paperwork to oppose the strikeout. The fishing company had some objections to the court's jurisdiction, so I had to write some paperwork about objections to the objections. And now I'm doing the transfer application. Then I'm moving on to apply for extensions in relation to the filing of personal grievances and extensions for the filing of the wages claim. And I'm going to make some other applications for disclosure and also applications to seek to rely on, say, the plaintiff's records and information if the defendant doesn't produce their wage records. They're saying, oh, well, we shouldn't proceed because we should not assume that they have the records. This is a company that has been sued in Admiralty. There is no 6-year limitation in Admiralty. They've been sued in Admiralty by other fishermen that worked on their vessels. So they are on notice that they need to keep their records as far as I'm concerned, and I've already been in litigation with them for 2 years, so they've had enough time to find their records. They're just full of excuses in my opinion. But it's just really quite hard going because there's a lot of paperwork, so I need to basically convert the paperwork I did for the ERA for the employment court. It would help to have the transfer. The Christchurch court doesn't seem to have an office down there for filing paperwork, so we've got to file the paperwork in Wellington anyway. So I've already had some trips to Wellington to hand bulky paperwork in, and down on a plane to serve the bulky stuff on the other solicitors in Nelson. So it's quite a lot of travel with it. I also need to attend all my clients in Indonesia to take instructions, and I send staff members out to do that. It'd be really great if we could have the proceedings in Auckland, could manage it with style. I think it would be good to have a major trial on these matters at Auckland, and it should be televised as well, because it's in the national interest that we hear these issues. So I'm doing some further videos after this just to go through the applications, and I hope that you found this helpful.